Hi everyone, today we are dealing with the criminal procedure, that is Study Unit 2, CPR 3701. The topic of the day is simply how to bring the accused before the trial court. We are actually responding to that question. So there are different methods in which the accused can be brought before court. So I've decided to summarize those different methods into 5, starting off with the use of a summons, the second one being the use of a written notice to appear, the third one being the use of an indictment, the fourth one being the use of an arrest, and the last one being the use of an extradition. So starting off with the use of a summons. Summons are used in a summary court in lower courts where the accused is not in custody and is not about to get arrested. However, the accused can also be arrested even after the summons have been served on him. But the procedure is only followed when it appears that the accused may try to defeat the ends of justice. So there is also a procedure that is used under the use of summons, which is in terms of the sections that I have highlighted there. In terms of section 54, subsection 1 of Criminal Procedure Act, the prosecutor draws up the charge and together with the information that is relating to the name of the accused, the address of the accused, the qualification and status of the accused, then the prosecutor takes that and hand it to the clerk of the court. That is in terms of the section. So the clerk of the court, in terms of the section, will issue the summons that are containing the charge that is coming from the prosecutor. And then together with the information that is relating to the place, the date, and the time in which the accused is expected to appear to court. That is done in terms of section 54, subsection 1 of the Criminal Procedure Act. And the prosecutor will then hand that to a person who is authorized to serve the summons. That is in terms of section 229. Then the prosecutor, after handing the summons to the person who is the police officer who is authorized to serve the summons, the person will then deliver the summons at the place of the accused, his residence, the place of his residence, the place of his employment, and or the place of his business if the person is running a business. That is done in terms of section 54, subsection 2, paragraph A of the criminal procedure. And the summons can be served anywhere in the Republic. So even if you were to serve the summons as you are in Durban, you want to serve the summons to Johannesburg, you can easily do so. So that it can be served anywhere. And finally, in terms of section 56, subsection 1 of the criminal procedure, the summons must be served 14 days before the date that is fixed for the trial of the accused. That is the first method that you can use. And the second method is the written notice to appear. This one is based on the peace officer. If the peace officer, on the reasonable grounds, believes that the magistrate court, when it is convicting the accused, it will not impose a fine that is more than the amount that is fixed from time to time by the minister, by the government gazette. Currently, it is 2,500. So if the person believes that the magistrate will never impose a fine that is more than that, he or she can hand the notice to the accused. And the notice is containing the following information. It contains the name of the accused, the address of the accused, the nationality and the age of the accused. And the notice is actually calling upon the accused to appear on a certain date, on a certain time, which is specified in the notice, to appear and answer on the charge that is against him. And the notice is also stating that is showing the place where the peace officer has signed the original and left it to the accused. That shows that he has successfully delivered the notice. And finally, the notice is also containing the provision of Section 57 of the Criminal Procedure Act, which states that the accused may admit on guilty and also pay the amount that is stipulated in the notice if the accused wishes so, even before appearing to court. That is the second method that is used. And the third method is the indictment. This one is used in the High Court as opposed to the summons that are used in lower courts. So at a trial in the Superior Court, there is a charge is contained in the document that is called the indictment. That is after being drafted by the director of the public prosecution. And then the indictment is actually containing the charge against the accused, the name of the accused, the address of the accused, the nationality of the accused. And the indictment is also containing the summary of the facts of the case. It is also containing the names and addresses of the accused. That is in terms of Section 144, subsection 1, subsection 2, and subsection 3 of the Criminal Procedure Act. And lastly, the indictment, the information that is also contained there is that it should give 10 days before the trial, unless the accused agree that they can be given a shorter time to appear before the court. That was the fourth method. And the fifth method is the one that you find that the courts or the justice system is reluctant to use, is the arrest. The arrest is actually infringing on some of the constitutional rights. For example, the right to freedom of security in terms of Section 12, subsection 1, and paragraph A, that you cannot be deprived of freedom arbitrarily. And the provision of Section 49 of the Criminal Procedure Act also stipulates the ways in which the arrest can be effected. It also states that the arrest may be even effected when there is no warrant of arrest. But what comes first is that there must be a warrant of arrest. There is no one who can arrest a person without a warrant of arrest. And it also speaks of the deadly force that can be used. That is in exceptional circumstances where you find that the accused does not want to cooperate. Then you will find that in those exceptional circumstances, the officers or private individuals may use a deadly force. But it also states that the use of a deadly force must be proportional to the purpose of the use. You cannot use a deadly force when the person is now or has surrendered or is now cooperating.